You just unlock the front door to your shop, and the lights are off. Your business partner's truck isn't in the lot. You walk inside, and their desk is completely empty. The family photos are gone. The laptop is missing. They left their keys on a sticky note that just says, "I'm done." It's midnight, you got customers pulling into the parking lot in 8 hours, and you suddenly realize you're running this entire business alone. When someone you trusted with your livelihood just vanishes, the panic sets in fast. You're probably wondering if they can legally do that, if they still get half the profits, and if you're going to lose everything you built. You desperately need to know exactly what happens now, and we're going to walk through the reality of exactly what you're standing in. But before we unpack this specific disaster, we need to look at how the law views your business in the first place. You've to understand the foundation, because the rules change drastically depending on the exact words on your original paperwork. Let's talk about the massive financial danger you're facing right now. Ignoring this problem doesn't make the missing partner go away, it practically invites a financial hurricane to destroy your shop. If you just ignore the disappearance and keep operating without addressing the situation, you might be setting yourself up for a massive lawsuit. Your old partner could suddenly reappear 6 months from now, right when your business starts making record profits. They could demand a giant payout, claiming they still own half of everything. Worse, their personal creditors could come hunting for you. A creditor is simply a person or bank that someone owes money to. If your ex-partner skipped town because they're drowning in debt, the people they owe money to might legally have a right to grab your business assets to pay off your partner's personal mistakes. Your delivery van, your tools, your inventory could suddenly have a lien placed on them. A lien is a legal claim that a creditor holds against property to force a debt to be paid back. If you don't untangle the web properly, your van could get seized to pay your partner's gambling debts. And if you've an active business loan or a commercial lease, the bank and the landlord usually don't care that your partner bailed. They want their money, and if both of your names are on that dotted line, they'll come after you for the full amount. You'll be footing the entire bill for a 2-person operation while trying to figure out how to buy out someone who refuses to answer the phone. So how do you resolve this nightmare? You've to look at the paperwork. The very first thing the law cares about is exactly how your business was officially structured. Let's say you and your partner never actually filed any official formation paperwork with the state. You just shook hands, bought some tools together, and started finding customers. In the eyes of the law, you automatically created something called a general partnership. A general partnership is a basic business arrangement where 2 or more people share the profits and are equally responsible for the debts. In a general partnership, a partner can technically leave at any time. When they do, it dissolves the partnership. Dissolve simply means to legally end or break apart the business relationship. But dissolving a partnership doesn't mean they walk away empty-handed while you keep the cash. They still legally own their share of the business assets. To survive this, you to buy out their interest. An interest in this context just means their percentage of legal ownership in the business. If you can't agree on a cash price for their half, you might be forced by a court to liquidate the business. You might need to ask a judge to appoint a receiver. A receiver is a neutral expert appointed by a court to take temporary control of the business, figure out the exact finances, and oversee the final split of the assets so nobody gets cheated. Going to court is the absolute last resort, because it's expensive and takes months, but sometimes it's the only way to force a ghost to legally detach from your life. When exactly do you need to get a lawyer involved in this mess? The short answer is immediately after you send that first written notice. If your business is worth anything more than a few $1,000s, you absolutely can't afford to guess your way through this process. Because laws vary heavily by state and constantly change, and because every single operating agreement is uniquely worded, you need a local attorney to translate your exact situation into plain English. A lawyer can draft a buyout agreement. A buyout agreement is a specific legal document that officially transfers the ownership of the missing partner's shares over to you, permanently ending their right to ever claim future profits. A lawyer ensures the language is bulletproof so your ex-partner can't suddenly return and claim you tricked them. If your ex-partner decides to get aggressive and tries to lock you out of your own business bank accounts out of spite, you need a lawyer to file an immediate injunction. An injunction is an emergency court order that forces someone to either stop doing something or start doing something. You need the court to force the bank to give you back full access so you can keep paying your bills and buying your materials. Trying to navigate an injunction hearing without a lawyer is virtually impossible. The judge speaks in legal codes, and the bank will have their own high-priced attorneys defending their actions. You also need a lawyer if you suspect your ex-partner took something valuable when they walked out the door. If they emptied the business bank account before they vanished, that's not just a breach of contract, that's a potential civil theft claim. Civil theft is when someone intentionally takes property or money that doesn't belong solely to them for their own personal use. Proving civil theft is complicated, but if you win, many states will force the person to pay you double or even triple the amount of money they stole as a severe punishment. A lawyer knows exactly how to file these specific claims and how to subpoena the bank records. Subpoena simply means a legal order that forces a bank or a person to hand over secret documents or records for the court to see. If your ex-partner took the company credit card and went on a vacation, you need those bank records to prove exactly where the money went. A lawyer gets you those records so you can demand every single dime back. Finally, you need to protect your intellectual property. Intellectual property means the intangible things your business owns, like your customer list, your website domain, your social media accounts, or your business name. If your ex-partner was the one who originally set up the Facebook page or registered the website in their personal email address, they could try to hold it hostage. They could change the passwords and try to ruin your online reputation just out of pure spite. A lawyer can send a stern warning letter, often called a cease and desist. A cease and desist is a formal written demand telling someone to immediately stop doing something illegal or harmful to your business. If your ex-partner is actively trying to steal your customers by using the company's secret client list, a lawyer can get an emergency court order forcing them to immediately delete the list and stop contacting your clients. The law takes intellectual property theft very seriously, but you've to actively enforce your rights to protect your property. Look, when someone you trust just walks away from a business you built with your own sweat, it's a massive blow. It's terrifying, it's infuriating, and it's exhausting. But you're not completely powerless in this situation. By understanding the exact rules of business structures, ownership interests, and formal buyouts, you can protect what you've built and survive this disaster. You just have to be proactive, document absolutely everything, and get the right legal professional in your corner to help you sever the ties properly. If you rush it, you risk losing everything. If you do it by the book, you can eventually walk away with your business, your sanity, and your wallet intact. If you had to buy out a business partner who ghosted you tomorrow, would you rather negotiate the price with them directly or let a judge decide the final number in court? Tell me your exact reasoning down in the comments. If this breakdown helped you understand the terrifying financial trap of a vanishing business partner, pass this video along to a buddy who runs a side hustle and thinks they don't need a formal operating agreement. Make sure you subscribe to Scribble Law so you always know the actual rules of the game before a business disaster tries to drain your bank account.